Good morning, everybody. Thank you for joining us for today's webinar. My name is Amber Hines, and I'm the owner of Ashbur. We specialize in Medicaid compliant annuities from A-rated insurance carriers. If you're interested in a copy of the handouts from today's webinar, feel free to download those from the handouts portion of the GoToWebinar dashboard. And then also, if you have questions during today's webinar, you can type those into the questions box of the GoToWebinar dashboard as well. I'm super excited that Attorney Todd Whatley is presenting today's webinar on Medicaid appeals and how to handle a appeal if you run into this situation. Welcome, Todd. And before we get started, I'll just tell you a little bit about Ashbur and my agency. We offer Medicaid compliant annuities from A-rated insurance carriers. We do very short-term annuities as short as 2 months. And we offer complimentary case analysis. So we will help you to determine the annuity amount, the term, and which assets your clients may consider annuitizing, especially if your clients have retirement accounts or existing annuities, life insurance, things of that nature that we're interested in doing a 1035 exchange or a direct transfer of. We offer assistance from the beginning to the end of a case, so we will help with providing quotes, providing the actual funding of the Medicaid compliant annuity, and then also if you have a situation where a client purchases an annuity and they pass away during the annuity term, we will also help with the death claim process if there's something that needs to be settled with the state Medicaid agency. We offer top-notch customer service as far as getting back to you, usually the same day with a complimentary proposal. And we would be happy to answer any questions that you have about working with us. So feel free to reach out if you have any questions. And now I'm going to hand it over to Todd to talk about Medicaid appeals.
All right, thanks, Amber. Yeah, I will testify. Amber and her crew does amazing customer service. We actually had a death case yesterday. So one of our clients died very quickly and no problem. So, all right, first and foremost, yes, thank you for having me. And this is an interesting topic that used to scare me to death. When I first started, I was like, oh my goodness, we've been denied. I've got to fight the state. It's going to be this big, huge process. And having done, I've lost count. I've done dozens of fair hearings, sadly, sometimes because we messed up, or sometimes the client messes up, or sometimes the state messes up. And so hopefully by the end of this, you're going to realize this is something that you probably should do, that there will be times that you should appeal this case. And there's sadly many times you have to appeal it because something's messed up. And so hopefully by the end of this, you will see how this process works and that it's not the big scary thing that you may think it is. And it's I actually kind of enjoy doing them because it allows me to get a point across and to make an example sometimes. And I'll go through this. So number one, to do good for your clients and your fellow attorneys, you should appeal some cases. Okay. There's, particularly on policy issues, if your state is simply not following the policy, you've got to call them on it. And the way that you do it is through the fair hearing. Okay. If you're a litigator, if you came to elder law where there's typically not a lot of litigation, if you're a litigator, this will be right up your alley. You should, enjoy this probably because it is a little bit lower key. But if you're not, and I am not a litigator, I don't like to go to court. I don't like that process, which is one thing that brought me to elder law. But even if you're not a litigator, it's okay. Okay. I'm going to show you how to do this and let you know it's really not a big deal. Okay. I think some people are surprised, surprisingly, you should know that an appeal is coming. Okay. Many times you can see there's a problem between you and the caseworker in the state, something's just not working out and this is coming, but then sometimes you'll just get a letter in the mail saying you're denied. And it's like, oh where did this come from? So, just don't panic if you did get this denial that you did not see coming. It's okay. All right. So first step obviously is try to avoid the denial. Typically a denial is something you don't want. And there are some reasons. Probably the number one reason is a failure to respond. So when you apply, if you've never done a Medicaid application, you will apply, do their application, send in as many documents as you can. And then the state will say, okay, we need this document, or a newer bank statement, or we saw this, can you clarify this? So they will send you a notice of action. And typically in my two states that I practice in, we have 10 days. So, okay, so we have 10 days to answer the notice of action and get that in. And if you don't, and don't ask for an extension or some issue with this, you will be denied, and they'll do it very quick to say, hey, you did not meet that 10-day deadline, so you're denied due to a failure to respond. Okay. One of my things to help avoid denials, and sadly, you probably have to do this after you've done a fair hearing with this caseworker, is I set up a good cop, bad cop scenario in my office. I have a Medicaid caseworker who does the applications for me. And if you are going to do Medicaid applications for clients, I highly encourage you, as soon as you think you can afford it, get a case manager in your office to do this. Your case manager is the one who will talk to the DHS caseworker most. She'll be emailing them, calling them, responding to them. Sorry about that. I encourage her to be her friend. Talk to the caseworker, be nice, be friendly, because there are sometimes, particularly on the failure to respond, if you just miss a date, it's like, oh, it was a busy week and I forgot. They can give you some grace period on that to say, hey, Sarah, I noticed you did not get us those bank statements. Oh, no, I forgot. I'll get those in today. They don't have to do that. If you miss that 10-day, boom, they can deny you. But if your case manager has a very good working relationship with the DHS caseworker, sometimes they'll give you some leeway. She sets me up as the bad cop, okay, to say, if you're going to deny this and not do what we think you should do, Todd's going to do a fair hearing. And when I do a fair hearing, I'm not nice. Okay. I am very to the point. It's like, you made me be here, so I'm going to make you pay for it. And that sounds really bad. I think I'm a really nice guy across the board. But when I get to a fair hearing, if they force us to go there to take time out of my day, my client's day, everybody's day, we've got to do this to prove some stupid point. I'm going to make my point very aggressively and make it so that that caseworker does not want to do another fair hearing with me. And so therefore, Sarah, my case manager, can call her and say, I'm going to have to ask for a fair hearing if you don't do blah, blah, blah. And they'll suddenly come around and say, yeah, I think I can make that happen. Okay. So it does work very well having that good cop, bad cop setup. So in some states, like I'm in Arkansas, our attorneys are not tremendously cooperative with us prior to the fair hearing. In Oklahoma, though, they give out their number, call us, let's talk about it. So figure out your state and see if you can just call the attorneys with the state and say, hey, here's the problem I'm having, here's what's going on, can we talk about this? And so try to avoid the denial by working with the case manager or the attorneys. Okay. There are usually a limited number of attorneys, and this typically is what they do all day, every day, and they can talk about it. And but sometimes they may not talk to you until the actual appeal is filed and there's a case number and things. That's how Arkansas is. Once I do the appeal, I can then talk with the attorney who got that appeal, and many times we can work it out. Then it's like, why wouldn't you talk to me before this? But they don't. Okay, so figure out what your state does and don't be afraid to call and talk, because they don't like fair hearings either. It takes time out of their day. If they can end this with a phone call, they would, but sometimes they just don't. Okay. So if you did not respond to a request for documents, number one, did you get the notice? I did a fair hearing last week because it was denied and they never sent us a denial. Okay. We had been communicating by email this entire time, and she denied our case and sent us a mailed notice, did not say in an email, this has been denied. She supposedly mailed us something. We never got it. And for 3 months, we keep asking this caseworker, what's up? Where are we on this case? No response whatsoever until I filed the fair hearing for failure to communicate. And that suddenly got everybody to say, oh, well, it's been denied back 3 months ago. And I'm like, well, we never got the notice. And the hearing, they have to prove that they sent you the notice. So if you get a denial or failure to respond or whatever, but if you get a denial and you don't have proof of that denial and they can't prove that they sent you that denial, appeal that. Okay. Even if it's with outside of your 30 days, until they can prove that they sent you the denial, that you got the denial, then you're still able to appeal that, and you should have a fair hearing, even though it's outside of your time frame. Okay. All right. If you did get the notice, whose fault is it that you did not respond? Okay. So when it's the client's fault, you're like, oh, good, that's not my fault. Word of caution. When you do Medicaid applications, when you get this notice of action from the state and you need something from the client, absolutely put it in writing. A lot of offices are now doing text, and a lot of our clients have cell phones and they do text, and so they would prefer us do text rather than email. Email seems to be kind of falling out of favor, but however you do it, even if it's a written letter, which takes forever, we don't do that. We do it either email or text. Put in writing that you have told the client that you need these documents, because when it gets denied for the client not getting you these documents and it's been denied and you're 6 months into this application, that's 6 months of unpaid nursing home bills someone's got to pay for. So they're going to be mad and they're going to come after you to say, you never told me. Yes, I did. Here it is in writing. So absolutely put it in writing that you did notify them that you need these documents. Okay. This is a very shaky appeal. I would almost just tell the client, look, we didn't get the documents. If the caseworker won't reopen the case with you begging and pleading, I really would advise you start all over. Tell the client, I'm sorry, but these months are not going to get paid. We're very serious about this. Also, practice point, in our Medicaid contract, we put in there that when we apply and we get a notice of action, we have 10 days. And if you do not respond to getting us those documents so we can get those to the state within those 10 days, you will be denied, and it's not our fault. So we tell them at the front, and then we prove it in writing that we ask you for these documents and you did not get them to us. Okay. This is the most common reason for a denial, and you've got to be careful. If it's your fault that you did not respond, that's not good. Okay. Again, having your case manager have a good relationship with the DHS caseworker, that's where this helps. It's like, oh, I had a terrible week, I'm sorry. And if they're friends, the caseworker many times will say, oh, that's okay, I've been busy, get it to me today or tomorrow and we're fine. Okay. You're like, good. So just be careful. Okay. Hopefully they will have some grace. And if not, if you absolutely want to appeal and it's a very expensive, I mean, there's no downside to appealing it to say, hey, we're going to appeal this and, plead undue hardship. Hey, you denying this because we were one day late or we didn't get you this one piece of paper to cause this much damage, 6 months times, 6 times a monthly nursing home bill. That's a lot of money. You're going to cause this family $48,000 worth of damage because I didn't get you one piece of paper. That's not fair. Okay. That's a undue hardship on this family. Please reopen this case. Let us get this to you and let's play nice. Okay. So you can appeal, and I probably would, just to help get, somehow get this to get fixed, because otherwise you may be responsible for paying that bill because you did not respond. Okay. All right. Another very common reason to be denied is you're over resourced. You have too many resources. So a lot of times clients maybe don't know that they have certain assets. Life insurance policies are very common. Sometimes land that they just forgot about. Assets were missed. Okay. So if you or the client really messed up and didn't report something that was there, there's really no need to appeal that. Okay. It's like, whoops, we messed up and we found it. So it's new assets that can help cover the unpaid nursing home bill, and you just kind of start all over again. All right. But what if it's just a little bitty thing, just, a $2,000 cash value on a life insurance policy? Well, that's not going to pay for a month's worth of nursing home care, nowhere near it. And it's like, oh, this is terrible. So if you found the resource and it's really not that much, typically my guideline is if it's less than 1 month's worth of nursing home care, you just argue, whoops, okay, we just found this. Please let us deal with this for this month, knowing that we are disqualified for this month. Okay, we just found the asset. And so we'll pay for this month. Don't make us go all the way back to the very beginning. Again, undue hardship. If this $2,000 asset is going to cost us $48,000 in missed nursing or unpaid nursing home bills, that's not fair. Okay. It's a very undue hardship on my client. Let's just say we'll pay for this month and then we're okay. So, be nice, or have your caseworker be nice and let them argue. But if it's a big amount and you found this big huge asset, it's like, okay, we got to start over. Okay. Again, get in writing, not again, but I have my clients get us their assets. We put it in writing and say, are these all the assets that you're claiming, and get them to admit that, so that when something else is found, it's not your fault. Okay. They can't say, well, I told you about that. Why did you not put it on the application? No, you never told me about it. Get it in writing, have the client acknowledge, sign the paper or something to say, yes, these are all of our assets that we know of today. This is what we're doing the application on. Okay. Sometimes the state will find assets. They have some super secret government program that will find assets. And so again, if you or the state just found assets well into the application, that's not huge. The state many times will have grace on you to say, okay, we understand, Mr. Twatley, we've worked with you for years. We know that you don't commonly hide assets. And so finding this, yes, you were disqualified for this month. Pay that in, get rid of it, do something with it, and this won't affect the entire application. Okay. But you have to be honest. You can't get by with this too many times. Okay. So, do a thoroughly research before you do the application. When the client comes in, quiz them as much as you can to get everything on the table, and encourage them to look in common places where things get missed, and that is life insurance and real estate. So go through those, make sure that you have everything that you can. Okay. Do a thorough search before you do the application. Again, being over resourced is not a great appeal. Okay. You can argue undue hardship, but you're begging for mercy rather than saying, no, I'm qualified. No, you weren't qualified because you had too many resources. You're begging for mercy. But sometimes you do that. All right. I'm assuming that you know what a snapshot date is. It's the first day that a person goes into the nursing home. Let me get that. Okay. So if your snapshot is wrong, okay, you did not have the correct assets when you did the split and spent down, there were more assets out there, which means that your number was bigger and you didn't spend enough. That's a problem. Okay. And not a great appeal because somebody messed up and it's not the state's fault. So if you just don't have the correct assets, again, get it in writing, have the client sign it to say, yeah, these are all of our assets. You can have the wrong date. Okay. My understanding of the rules, and I've done this before and I've argued and I've always won, is that you get to pick your snapshot date. If they had 30 days in a nursing home a year ago when they had much more assets, you get to pick that date as your snapshot date to say, hey, he was in for more than 30 days. He came home. They spent $100,000 upgrading their home. And now we're in the nursing home to stay. And that $100,000 should go back to the snapshot date and we get to spend less money. We've already spent money. And so therefore, sometimes you can get them on Medicaid quickly having a previous snapshot date rather than the current one. And so if the DHS caseworker says, oh no, this one today is the snap, or this stay most recently is the snapshot date, you're like, no, 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 no. I want to go back to here. They have to let you do that. And so that is a argument that I would make. Okay. Policy disputes. Okay. This is where you can really make a difference. And I think this is what made my name in Arkansas as the attorney who's made the state change their mind on a number of things. Okay. You can really make a difference if you're seeing that your state is not doing what they should be doing. You need to appeal based on policy issues to say, no, here's what the policy says, here's what your policy says, here's what federal policy says, and here's what you're doing. And I had one of those that was just pretty straightforward. And the state was like, we just don't want to do that. And I was like, okay, well, we appealed. I lost in the fair hearing. I went to the judge, circuit judge in my county, presented this, and the judge literally looked at the state and said, here's what it says to do, and you're doing this. How does that compare? And they're like, but judge, blah, blah. And he's like, you got to do what the rules say. And I was like, thanks, judge. It was a very easy win, but I had to fight for a year because they just didn't want to follow their policy. And it blows your mind sometimes that you don't follow your own rules. So realize that the state office doesn't do what the rules say sometimes. So if the policy is not clear, but it's been litigated and settled, there's really no need to appeal. So this is where you really do need to have a pretty good relationship with fellow elder law attorneys in your state, and particularly those that have been around a while and have done Medicaid for quite some time. Pick up the phone and say, hey, I'm having this issue on this policy. What's the deal? And they may say, like, if you called me to say, hey, Todd, on this, oh, it's settled, I've litigated that, it's done. And real quick example, if a community spouse sells their home after the institutionalized spouse is in the nursing home, if they sell their home, all of that cash money from the sale of the home goes to the institutionalized spouse. That's blatantly wrong, but that's what they're doing. And I've litigated it twice. I won once and I lost once. And so I've pretty much given up to say that's just how it's going to be. And so if a younger attorney called me and said, hey, Todd, my clients think about selling their home, what's the rule there? I'm like, don't. Okay. Either sell it and buy a new, put the money into the home. But if you're going to sell your home and turn it into cash, that's a problem. And so that's where work with or have a good relationship with attorneys out there to say, hey, has this been litigated? And I don't want to mess things up, which is my next point is don't appeal something that can mess things up for others. So if it's a policy issue, I would ask around to say, what do you think about this? And they may say, yeah, I've been battling this for years, and yes, please fight it because it's not right. And that's what I did. I was basically the second elder law attorney in Arkansas, and the first one didn't fight much. And so I litigated a whole bunch of things and won and got them to do the right thing. All right, charging or not charging. This is kind of obvious, but if it's your fault that you messed up and you need to appeal, you obviously don't charge for that. Okay. But if it's not your fault, okay, do we charge or not charge? So, number one, if it's a policy issue that you really want to make, try to get your client to pay for it. If it's a single person and they're now qualified for Medicaid, they don't have any money. And I don't, if you have a family who's willing to pitch in, they may pay, but the client themselves can't pay because they're out of money. But if they're married and you just protected $400,000 or you're trying to protect $400,000 or $500,000, they can probably pay for this and they should help you do this. But if it's a policy issue that you really want to get across, don't charge, just do it. Okay. Take the time. It's for the better good of everyone. If this is truly the client's fault that you're having to do this, absolutely, you should charge. Okay. If the client messed up, did not get you documents or withheld information or whatever, I would charge. What if they don't want to pay? Okay, then you're kind of in a rough situation because your our ethical rules say that we can't leave a client in a bad situation. We can't just say, okay, fine, I'm not appealing this. Well, you got to get this resolved somehow. And I can tell you, I have done more free fair hearings than I've done paid. Okay. So it just kind of works out that way. Here's a practice point. Okay. Put in your contract that your Medicaid fees, that what you're charging them to do the planning and the Medicaid application and all of this, you would think I would put, okay, you're paying me until I get your application approved. Well, that's what my contract said until I got caught up in litigation and had to do a fair hearing and then go to court. And my client refused to pay because it said, he pointed in the contract, your contract says that you will work on my case until it's approved, and it's not approved yet. And I was like, crap, you're right. So I had to do all this litigation for free. So now my contract says my fee covers you until we have a final decision from the state. And I don't use final, by the way, until we have a decision by the state. So if you get a denial, your contract is done and you have the freedom to not appeal if they don't pay you typically. Don't put until we have an approval, put decision. Okay. And that will keep you from being on the hook to do these appeals because you did not get an approval. All right, the process. You must appeal within the time limits. If you got the denial, okay, number one, if you got the denial, then you've been made aware of it and you have a set length of time. I think it is typically 30 days. Okay, so you have 30 days from the denial to appeal. If you're appealing by mail, I would send it certified with signature. Okay, you have to prove that they got it on this date within your appeal. I've done an appeal on that very issue when I did not send it certified, and the judge was like, Mr. Watley, how can you prove that they got it within their 30 days? Their point was you did not appeal within 30 days, and I couldn't prove that I did. So learn from my mistakes, please. Okay. If emailed, and sometimes you can email it, request acknowledgement, and don't think they've got it until you have an email back from them saying, we got your request for an appeal. So you have it dated and know that it's been done. Okay. your rules will tell you, your DHS policy will tell you toward the end, it'll say, here's how you do appeals. Read that, follow the rules very closely because it does start to get sticky. You will then get a letter from the administrative judge to say, we have received your request, and don't be afraid and it will have the date of the appeal, okay, or the fair hearing. If that date, if you're busy that day, if you have things that you can't move, just call them. They're used to working with busy attorneys. They will change it. I've never had an issue with them saying, yeah, that's fine. We'll scoot it back some more. There will be information in this letter about how it's going to be held. It will also tell you if you need to subpoena records from them. It will tell you how to do that. Typically, you ask the judge, and the judge will get those documents for you. So that's kind of nice, right? Okay, before the fair hearing date, you should get a hearing packet from the caseworker. It's a thick packet of everything that they have on this case, so that you have that. The top page typically is the notice, is the hearing statement, okay? It's there, it summarizes your case and says why you were denied. They should quote policy in there to say we're basing this on this policy number. Not that it really matters, but it's just kind of embarrassing to the caseworker. Research those, and if it's not the right policy numbers, bring it up. And it's like, why did you quote this? And they're like, oh, I don't know. It just kind of gets you a foot up to say, you messed up on this, so obviously you've messed up everything else. And so the fair hearing I did last week, her reason for denying the case was a failure to respond, which we did respond. But she said we didn't. And then 3 months later, we figured out she had denied us. Well, her hearing statement, her reason for the denial was the policy that talked about vehicle valuations. It's like, what's this guy? But she didn't show up for the fair hearing, so I couldn't bring that up. But research those and just make sure that they are basing it on the correct policy statements. All right. Meet with your client and the people that are going to testify, possibly your caseworker or anyone else regarding the issues that are going to be brought up. Interesting point is, even if it's not facts that are in dispute, it's just the policy. Typically, your clients aren't going to testify on a policy issue matter, but they still have to be there. Someone's got to be there to represent the applicant at the hearing. Just tell them, I really doubt that you're going to say anything. It's going to be me and that attorney going after it to figure this out. So don't sweat, okay? If it is fact-based, review the facts with the clients, remind those who testify. This would always frustrate me because, you know, in court, when you're cross-examining someone, you want yes and no answers when really a yes or no doesn't fully answer the question. Just remind them of that and say, the state attorney may ask you a question that you feel like you can't fully answer and they don't let you fully answer. Just chill. I'll come back to you and say, Sam, you tried to answer the question, but the state attorney didn't let you finish it. What did you need to say? And then they can finish, okay? And so that frustrates clients when they're not used to being in court. And so just remind them of that. That's probably the number one thing that I try to make sure, look, I'm on your side. I will get that information out of you. And remind them about objections, okay? Know your policy, okay? Know what the policy says. You should be very familiar with the policy going into this fair hearing to be able to back up what your issues were. And don't be surprised if the caseworker doesn't have their policy with them. I am famous for walking through the policy to say, this is what it says versus what you did. And I want them to go through the policy. And a lot of times they're like, well, you know, we'll open up the hearing and I'll say, do you have your policy with you? And she's like, no. I'm like, well, you're going to need it. And so sometimes we've waited 10 minutes so they can go find their policy wherever it is. And I make them go through it so that it jumps out at them to say, here's what the policy says, here's what you did, and those two things aren't the same. All right. Realize a fair hearing is not fair. It is you versus the hearing officer, who is a employee of the state. It is the caseworker, which you've been fighting against for months, and the attorney for the state. So it's 3 versus 1. Remind your client of that and say, this is not fair. This is just how it happens. Okay. This is usually done on the phone. Even before COVID, it was always done on the phone, which gives it an appearance of not being serious, but trust me, it's serious. Okay. It seems unofficial, but it is being recorded. And typically, I think most states, I'll bring this up later, but this is all the hearing statement, the transcript of the hearing is all that the circuit court judge is going to see. They don't bring in new testimony. They only look at that transcript. So that's got to be correct. I lost a case one time, and I'm just being completely honest, learned from my problems, okay, that I've done in the past. My client said something, the attorney for the state asked my client something. I thought, oh, wait, I don't know. And I was thinking through that, trying to figure out, this probably should not come out. And finally I objected, and I was overruled, and they continued. And so my appeal basically was on that very point. My appeal to the circuit judge was on that very point. And the judge was like, yeah, that information should not have come in. But Mr. Whatley, you objected 2 pages later rather than then. And your failure to object allowed that to come in. And I'm sorry, but you lose. And I was like, oh, that's real fun when your client's sitting right there beside you at the table. And the judge says, yeah, you lost this case because of you. Okay. So stay on your toes, object when you think something's coming out that shouldn't, because it is serious. Okay. The one thing that surprised me is for this to be a hearing type thing, our state, and I think most states do this, is they allow hearsay. It's a free for all in there. Oh, she said this and she said this. And it's just like, wait a second. And my first few fair hearings, I objected on hearsay, and the judge was like, Mr. Whatley, you can do that here. And I was like, what? You can do hearsay? He's like, yeah. So I was like, fine. So we just use it to our advantage. Okay. Sometimes the judge will give you the opportunity to do an opening statement. I usually take advantage of that so that I can plant in the judge's head what's coming up. And I've always used it. Absolutely, definitely use your closing statement. Okay. Okay. The fair hearing. Everyone who testifies will be sworn in. You have to tell the judge who all's in the room. Since you're doing this by phone, they typically want to know who's in the room with you. I've been surprised also that the judge may not let but one attorney speak. Okay, it just gets confusing on the phone. And so sometimes if you do have 2 attorneys in there that you're working on this case together, and the other attorney wants to say something, many times the judge will say, nope, just one attorney from your office can speak. And so just be prepared for that. Okay. The caseworker will read the hearing statement, that page that I told you, be very familiar with. They will read that, and then the ALJ will decide who starts, and it's just basically a hearing after that. Okay. Don't be surprised if the opposing attorney doesn't know the case very well. I have asked them before, when did you look at this? And they're like, this morning. Okay, good. And you can and probably will be more prepared for the case than the attorney. All right, so you get through the hearing, you've done it, you will get a written decision from the ALJ. Only once in the hearings has the ALJ decided in that hearing that I won. Okay, there's been some very clear cases. I'm like, yeah, I know I won this, but they always put it in writing. But one time they're like, this is my decision. I was like, oh, okay. Expect to lose. Okay? And I know that hurts and may hurt some people, but it's expect to lose because it's not a fair process. It's you versus 3 other state employees, okay? Unless you had absolutely clear policy argument that could not be interpreted in any other way than the way that you said, and the facts clearly fall in your favor, expect to lose, okay? Just expect it, okay? It's okay, okay? Because losing here is not the end of the world. You go to what I call real court with a real judge, and you will do much better there. Tell the client that you don't expect to win. Set their expectations to say, I know what I did was right. And here's the way I read the policy. Here's what they did, kind of explain to your client what your situation is and say, I'm pretty sure I'm right, but expect to lose. This process is not fair. It's rigged against us. We will probably lose, but don't lose heart. We're going to go into circuit court and fight it there, and we do much better. All right, you lost. Okay, yep, that's what I was expecting. So what if it was a bad case? You just appealed just to save face or try to beg mercy or whatever. The ALJ was right. Tell the client the news. You aren't surprised, and they're not surprised to say, yeah, we lost, because they expected to lose. Now, if it's a bad case, don't take it to court. Just talk to your client, have a heart-to-heart to say, look, things are about to get real, and we're going into real court with a real judge with some real time on my behalf. And if you're adamant that you don't want to do this, you can't tell your client we're not doing that if they want to do it, but you can pretty much price them out to say, look, this is real court, real judges. I'm going to charge $350 an hour to do this, and I have no idea how many hours it's going to take. I need $5,000 up front to start this. And they'll be like, but it's like, yeah, this is real. And many times they will not do it. Okay. But it depends on what they lost. I mean, what is your fair hearing about? How many months are you going to lose? It's a dollars and cents thing. Okay. Most clients won't pursue this due to money. But if the ALJ is wrong and this is worth pursuing, try to get some money from your client. But again, take the case to court to prove you're right for the greater good. Okay. The attorneys in your state, the people of your state will appreciate you doing this for fixing this issue, to say this is not correct and get the state to change their policy. Okay. The court appeal. Okay. You obviously do have to file to get into court. And it's a pretty straightforward process or form. And I just got it from another attorney in the state and just used theirs. Okay. So as I mentioned before, most states, this is not a de novo appeal. You are stuck with this record, and that's why you've got to make the record very clear and object when you're supposed to object. Once it's filed, I would go talk to the judge. They don't see many of these, so don't be surprised if the judge has no idea what this case is about. Okay, they're like, I didn't do Medicaid as an attorney. I don't see these cases very often. I have no idea. So therefore, they would typically welcome briefs. Okay, yeah, send me a brief, get me up to date on the rules. And this is where you can really shine and kind of admit new stuff that maybe did not come up in the hearing, but you can submit a brief, educate the judge to do it, and hopefully you have more time to do it than the state attorney does. All right, and you can spend some time on this and really do a good brief explaining why you're correct and see what the judge says. And I've had much better experience in circuit court than I did in the fair hearing. Okay. So this hearing is essentially you reiterating the policy and how you followed it and how the caseworker was wrong and the ALJ is wrong. Okay. Again, I've done much better in these cases, but the cases I've lost have been very frustrating because I don't appeal cases that aren't worth appealing and that I know I'm right. And, like that, the situation on the community spouse selling the house, I won one and I've lost one. The one I won, the judge was like, yeah, clearly that's not right. And the one I didn't, basically the judge was like, I don't know what this case is about, but the state's the state. They're the ones who do it. So I'm assuming they're right. And I was just like, okay, thanks, Judge. And my client did not want to appeal it into appellate court, and I didn't want to either. So it's like, fine, we'll just stick with it. Practice tips. Fair hearings are a pain. It's something, it's not typical day that you do a fair hearing. You want every case to go as planned. You get the approval. You get to pull your money from your IOTA account to pay for the final thing. Your client's on Medicaid, they hug your neck and you move on to the next case. That's how it should work. But sometimes you get denials, okay? And you will do an appeal at some point because things just don't go right. Don't panic and don't shun them, okay? They are good for everyone, particularly the policy ones, okay? If you're doing the policy, it's good for your client, but it's good for the rest of your state. Take the stand and do it. Get help, okay? Like I said before, run your case by some people in your state who have done a number of these. So get some experienced elder law attorneys in your state to run this by and say, hey, am I just wasting my time, or is this something worth pursuing? Okay. They will advise you because they don't want you taking bad facts to a fair hearing, and particularly into court. Okay. Bad facts make bad law. If this process scares you, get a mentor. Typically, there are attorneys in the state that you don't directly compete against. They sometimes will be glad to help you do this. It's, from any amount of help will be great to sitting beside you during the fair hearing. Okay. Ask for help if you need it. I can help you. I don't know your state rules, but I'll learn it. Okay. So get someone to help you. And for Amber's cases, if you buy an annuity from her and the reason for your denial was the annuity, she will pay me to come help you do this fair hearing. But me personally, as an elder law coach, if you have a fair hearing coming up or you think you should appeal or whatever, give me a call. Let's talk about it. And if you want my assistance to do that, I will help you do that. Okay. And I would love to talk to you about that to do that. And so here's a link, the Elder Law Coach .samcart.com products/fair hearing support. Okay. I charge $1,500. You can bill that back to the client, or if they're broke and you just really need my help, it's worth it to have someone who's been through this before, can walk you through it. They don't scare me much anymore. And so let's jump on this thing. Let's do it. Let's get it done. For my coaching clients, that's part of my service. And I've done this, not the fair hearing, but there were denials, and I worked with him to get through 2 of them in 1 month. It was his first month of coaching. So I was like, man, you lucked out. And so we jumped on him, got him fixed. And thankfully, he did not have to write a check, and we got him through. And so it was a very, very good case. Okay. So I do coaching. I love what I do. I love elder law. I love doing this, but my focus now, and I still do practice law on Tuesdays and Thursdays. I still dress up, come into the office, I see clients, I do cases, but my focus now is really doing coaching. I want to help you get up and go and do better and teach you how to do this. So I learned the hard way. I did not have a mentor. Like I said, I was the second elder law attorney in Arkansas. The first one did not want to help, did not give me any support whatsoever. I learned this the hard way, and it took me a hard 5 years to do it. Okay. I've worked out a process, and it's been proven to be true that if you work with me for a year, if you don't know anything about elder law, I can get you from knowing nothing to being a very proficient elder law attorney within a year. I have the training videos, phone calls with me, whatever you need, presentations, paperwork, contracts, phone calls. If I need to come to your office and do something, I'll do it. Okay. I want to get you up and going. I want you to be a good elder law attorney so you can help people and honestly have the best job in the world. Okay. My website is theelderlawcoach.com. 10 minutes, Amber.
Awesome. Well, it doesn't look like we have any questions yet, but I'm going to wait a couple minutes here if that's okay with you, Todd,
Sure.
just to see if people think of questions.
Yeah, I'm surprised because this is a
It was just
process and
that good, Todd.
do what?
I said it must have just been that
I answered all the questions. Yeah, I don't
good.
think so. So yeah, I just encourage people. I'll just say a few things. They used to scare me because, and particularly the ones where we messed up a little bit or something, and it can be scary. Okay, your clients looking at these big damages, and I will tell you, I have written some fairly substantial checks because we messed up, and I used to that used to embarrass me and I wouldn't talk about it until some other really close friends that were elder law attorneys would say, "Hey, have you ever done this?" I'm like, "Yeah." And they're like, "Yeah, me too." And it's like, "Yeah, this cost me money." And, everybody makes mistakes. And since I've started coaching, people are very honest with me, obviously, to say, this is what I did and I messed up. And so don't be ashamed. I've done it. And I've been president of the National Elder Law Foundation, and I'm not perfect, okay? Everybody messes up, but it's what you do after the mistake that defines you, okay? Don't do it alone. Don't be scared. Don't walk into this forest unarmed. Let me help you. Call me. Let's talk about it. I don't charge for the first phone call. Let's just talk about it and see what you need, see what I can do for you. I want to help you and I want you to call me, and feel free to call me. There's my number on the screen. Please let me work. I love what I do. I've probably made the very same mistake that you've made or the policy or whatever. Please let me help you.
Okay, we do have a question here. It's from a Pennsylvania attorney, and she's just saying to answer this question generally, it's saying, what type of court or judge do you usually file with after the fair hearing denial?
Okay. The policy will tell you what to do. And actually, at the end of the fair hearing, the ALJ will say, if I rule against the applicant, they can appeal into blank court. They'll say it, but your policy will also say, here is your next step after the fair hearing. So it'll tell you which court to go into.
Another question here is, when you make a mistake and have to pay, is it your account or insurance? My business account isn't quite that yet, which makes me think I should wait until it is before doing Medicaid applications. Thoughts?
Uh, don't wait. Yeah, don't wait. So I have never filed a claim with my insurance company. Okay. Because I don't want my rates going up. I've called before. I messed up a case really bad one time, and I called, and so they said, "Well, we need you to have another elder law attorney look at this case and tell us you messed up and send us a report for that." And I was like, "Oh, I don't want to do that. I don't want to call my friend and say, 'Hey, can you explain to the insurance company how I've screwed this case up?'" And so I was like, "Okay, never mind." Um, you typically owe money to the nursing home. The nursing home is a big corporation. They're not going to go out of business if you don't pay them this $20,000. Probably the biggest check that I had to write was $20,000. I was exactly like you. I was new. I didn't have $20,000 in my account. On most months, if I'm finished with 3 or 4,000, I was happy. Okay. So you call the nursing home and say, I messed up. Okay. Tell your client first, I messed up. I'm going to take care of this. Call the nursing home. And what I did was I called the nursing home and I said, look, here's what I did. I messed up. I admit it. I will get you the $20,000. Can I send you $2,000 a month for the next 10 months? They can't say no because it's like, well, okay, fine. I don't have it. You can't get blood out of a turnip. And so I'll send you $2,000 for the next 10 months. And they're like, yeah, that's fine. So work out a payment plan, do something, but just, yeah, I've never filed a claim with my insurance. I've always paid it out of pocket, but don't start to do this. This is the best job in the world. Don't start don't not start because that scares you. Call me. Let's work it out. Let's try to, number one, don't make that mistake. And number two, if you do make the mistake, let's try to work it out, minimize it or something. It'll all work out. I promise.
Okay, looks like that is all the questions that we have here, Todd. I'm not seeing any other ones.
Okay. Well, thank y'all very much for attending today. And please, if I can help you, don't hesitate to call me. I want to talk to you. I want to help you through this. And I can almost promise you, if you've made a mistake and you're thinking something's messed up, I've probably done it. So don't be embarrassed. Let's talk about it. Let's get you through it. Okay.
Awesome. Thank you, Todd. Thanks for the great webinar today. And thank you,
Welcome.
everybody, for joining us.
Okay. Thanks. Bye.